Date is wrong. Can you give the case number to be mentioned tomorrow? For correction tomorrow. This date should be 26th. This date should be 28th. Just find out from the website. Tomorrow, place it along with the. Any other mentioning? No. Wait 1 minute, just wait for 1 minute. Number 1. I am applying for the state.
It has. This is the translate copy of the FIR.
Copy of it? They can check.
Yes.
Malad. Corroborating injuries. Malad. Acid.
Yes, chassis submitted, my lord. Things, my lord.
But this is the translated copy of the 161 statement of the victim. I'm handing up the injury report, my lord. এটা একটু দেবেন করতে এখান থেকে দেবেন হ্যাঁ এই জন্য victim W is Nitai. Yes. Papan Das alias Tutun is the petitioner. No, W is not. I don't find the name of W in the FIR. That's why. Yes, sir. It's Nitai. No, my lord. Who is W? Oh, there are 6 persons named in 161. Yes. And in FIR there are only 5. Yes. FIR has been lodged by the mother. Lodged by the wife of the victim. Wife of. He is married. My lord. Oh, his wife is the informant. Wife is the de facto complainant. Husband is the victim. My lord, I have handed up the injury reports. My lord, page 25 to 42. Medical, all documents, my lord. And my lord, charge sheet also submitted. Our interesting part is that, my lord, the case is of 2014.
Yes.
Oh,
Charge sheet submitted in the year 2017. We are in 2025, my lord. Still, this petitioner is still absconding. my lord.
This petitioner is not a principal accused person. Some person arrested and subsequently enlarged on bail by this honorable court.
This is the scenario. my lord.
you are?
There is a,
Who are you?
I am the Shapun
Topon.
and my lord Mitin Rai
Named in the
and Kalipodo
constitution
Rai.
accused number 1, my lord, by the victim.
Here there is only accused number 1.
Yes.
Yes.
The rest?
At least 3 is granted bail, my lord, by this honorable court.
Out of 5, my lord, 3 are on bail and 2 still absconding. One of the absconding person is before your lordship.
Then why
Another person still absconding.
should you be granted anticipatory?
But I am not a principal accused person. I am the friend.
Who
of
is the
Mitin.
principal accused person?
Mitin Rai, my lord.
From
There
where
is
do you say he is the principal accused
Well,
person?
So there is no
Instruction,
specific.
Ah,
activity.
let him. How do you say he is the principal accused?
an instruction of
As per instruction,
Mitin Rai. and
someone
the-
will
the
become a
prosecutor
principal
is the-
accused because you are instructed by your client,
Mitin Rai and
or
the
it has to be borne from the FIR.
public court Karigar is the friend and there is some dispute for that alternate.
How you say he is the principal accused? Principal accused will only be on the basis of allegations. Somebody can't instruct you that he is the principal accused. And everyone will say, I am not the principal accused.
And the friend
What a
of Mitin
submission.
Rai.
Yes, heard learned counsel for the petitioner and learned counsel for the state as per
Number two, Madam. And the calculated copy of the list of the affair.
In the opening line, you say that a translated copy of the FIR has been supplied to the court, comma, after due service upon the state council in all the orders.
There is zero leak. Now, was recovered.
She has been recovered.
And number three.
I'm for the statement. Active judicial statement, Lordship. I'm asking.
Calculated copy of the affair.
You have given copy.
Direct to the.
Counter, I was counter के गाड़ियाँ they came to my house and I assaulted their.
She is 15 years old.
Yes, Lordship, 15 years old. And medical also done, Lordship, I already handed over. So item 4, CD not put.
Item number 4,
CD not put is item 4.
Not today.
item number 5,
My lord, I have for the petitioner. I have for the case under section 498A and 306 of IPC. My lord, the petitioner are father-in-law and mother-in-law of the deceased.
Father-in-law and mother-in-law.
Father-in-law of the deceased. They are 66 years and 63 years. My lord, the allegation, total allegation.
Where is the translated FIR?
My lord,
Come with the translated copy. Not today.
My lord, I have memo of evidence, my lord.
No, I would like to see the FIR. Don't give a summary, give a translated copy.
Number 6, my lord, same. Which
Well,
was
item number 7, no? Ajra, yes, already, both cases. Not.
Grateful, my lord.
number 7,
Lordship,
Lord, I have-
Record an order in both the matters, record an order, learned counsel for the petitioner submits that a translated copy of the adjourned for the day.
Lord, in item number 7, I am for the petitioner. Lord, this is the translated copy of the.
Well, I'm serving a copy to the state council.
Let's say CD not put it one day.
Not today. The Learned State Council does not have the CD. Full stop. He does seeks a not today.
Number 8.
I'm appealing for the petition, which is for relaxation of the condition. The petitioners were granted bail on 9th of July 2024 by the Honorable Coordinate Bench. The charge sheet has been submitted. I'm paying for withdrawal of Thana Hazira. That condition may be.
Hmm. So what is the relaxation that you seek?
Lordship, for withdrawal of Thana Hazira, the petitioner may not go on.
Why investigation is complete?
Completed, Lordship.
Then it says only till investigation. Then where is the question of withdrawing anything?
Should the petitioners appears that they will.
Just read the order
It's here in the order sheet, but.
till the conclusion of investigation. So what is there to be relaxed? Application has been filed seeking relaxation of conditions.
Number 9.
Number 9, I'm appearing on behalf of the petitioner. Your Lordship.
Has the notice been issued to the respondent?
Yes, Your Lordship.
They have appeared.
No, Your Lordship, they have not.
Have you filed affidavit of service?
Your Lordship, I have annexed that is in page 58, annexure H. Of
No,
my-
that is notice for arbitrator,
Yes, Your Lordship.
notice of these proceedings.
These proceedings, it is a ex parte proceedings on the first, after admission, if your Lordship pleases, then there would be a direction to serve upon the respondents, Your Lordship. That is the.
Where is the procedure? I want to see. Where is the procedure? There must be a arbitration procedure in the rules, High Court rules.
Section 11, Your Lordship, the.
No, 11.6 is for appointment of arbitrator.
arbitrator, but if
The
you're.
procedure must be prescribed by the High Court, whether it, this is the first time I'm taking up, therefore I'm asking you, what is the stage at which notice is issued?
Yes, your lordship, usual practice is that after admission.
Where is the
like
procedure? Can you,
revisional application, that same way arbitration petitions also gets admitted.
can you show the procedure? There must be a rules under the act made by the High Court.
Your lordship, then the appellate side rules I need to.
Please see it. Tomorrow we'll take it up. Not today. Leave it in the chamber.
Number one.
Yes. Has given 2 copies of that judgment. The judgment. And there was Swami.
Since the extract was relying only one paragraph, so I have just photocopied it, 2 copies.
811.
811. So that in this connection, it is well to remember that the reservations under Article 16(4) do not operate like a communal reservation. It may well happen that some members belonging to, say, scheduled caste get selected in the open competition field on the basis of their own merit. They will not be counted against the quota reserved for scheduled caste. They will be treated as open competition candidates.
It's very settled law.
Very settled.
So many judgments.
So many judgments. I mean, the point, Millard, on which I was, Millard, trying to persuade your lordship, is that, Millard, once the selected candidates got exhausted, from the waitlist candidates, they called several number of candidates whose marks were lower to me. Though I was selected in the first screening round, in the first round of the selection as a general category candidate. Thereafter, Millard, even if I have been relegated as an EWS candidate and I failed to submit my certificate, merit should have prevailed. And if, Millard, I would have treated as a general category candidate, my rank in the wait list would have been 7 or 8, whereas they continued till 56 in the wait list. And that's precisely, Millard, what my case is. That I ought to have been treated as a general category candidate. Now, Millard, so far as Millard,
So the primary question which we were asking you the other day,
yes, Millard,
that is the only hurdle as prima facie till now which we see.
Millard.
Whether you cross that hurdle or not, we don't know. Once you have failed to establish your claim as a reserved category
Yes,
by the set parameters,
yes,
the procedure contemplates that you will not be considered. So once you have failed to establish that you are a member of the reserved category, where is the question to rely on 811? 811 is where a person is admittedly belonging to a reserved category, SC, ST, OBC, whatever.
Right.
There is no dispute on
Right.
his
Right.
on his eligibility by virtue of the category in which he is claiming a reservation.
Right.
Then if by virtue of merit he exceeds the performance required for reserved category, obviously he can cross over that. It is a one-way migration. From this side, people can go there. From
Right.
there, people cannot come
Cannot
here.
come.
This is a settled law.
Right.
So then in your case, you have never established your claim as a reserved category.
Millard,
You
can
could
you-
not fulfill the requirement of a reserved category.
If Millard, I try to, Millard, look at this in this way, I applied as a EWS category candidate. Now, for certain reasons, beyond my control or within my control, I cannot establish that I am a EWS candidate.
So what
will
is
be
the effect?
consequence?
So what is the effect?
Millard, the effect cannot be cancellation of my candidate.
No, the effect in terms
effect
of
is-
your which category do you belong to?
Millard, I have to be treated as a general category candidate if my marks
That's
justify
not
such
that's
treatment.
not the point. The point is staking a claim as a particular category candidate, which is falsified because you do not
No, Millard,
submit the requisite credentials for availing that category.
Millard, I would
Then
just,
you have
Millard,
made a false claim.
No,
Can
Millard.
you contend that you must be considered at all?
No, Millard, I'll just, Millard, beg to differ on one point here, Millard. The word falsification, Millard, probably won't attract in
It
my
will.
case.
There's only one requirement.
I
It is
applied,
it is,
I
it is,
couldn't furnish
it is,
the certificate.
it is not EBC, it is not SCST that Ram Kumar Gijroya will come to your rescue.
Right,
It is a EWC.
EWS. correct.
EWS means for one financial year.
Correct.
Either you have the certificate or you
I
don't.
don't have a
It
certificate.
is your candidature will alter every year if you fail to submit the
From the
certificate.
subsequent communications, your lordship has seen, since the entire concept of EWS reservation was in the nascent stage, even they were giving extensions because different states were following different guidelines.
We don't
to
know,
issue
we
the
don't know, we
certificates.
don't know because
But
it
extensions
corresponds to a period when there was large scale effect of the COVID-19 pandemic,
Right,
COVID-19
right.
pandemic.
Right.
Perhaps that is why they have given two opportunities to all to come out
Yes,
with a
yes,
certificate.
Yes.
Others have come out. It's not that nobody could do it, but you couldn't.
But Millard, as a matter of fact, the state of West Bengal, Millard, only EWS certificate was issued 2021 onwards. And Millard, for me, for 2019-20 year, that was not possible because as per the DOPT guidelines and the central government guidelines, you cannot go back to the preceding 2 years. You can at least, the certificate has to be for the last preceding year. So in any way, it was beyond my control to procure a certificate. Millard, the case.
That's not your case.
Millard,
That is not your
no,
case.
we have not made out that case. We have
That's
just
not
stated
your
in my affidavit that since due
In
to
fact,
COVID-19
you
pandemic,
have
I
never
need a
told the
certificate.
authorities that it is an impossibility that you're requiring me to perform.
But Millard,
Only when
Millard,
everything has happened,
before the last
then you have.
extension, before the last extension, come deadline of the
No,
last
no, no.
extension,
You have
Millard, I
never.
stated.
Show us
Yes,
where
sir.
you have said.
Yes, Millard, kindly take my affidavit, Millard, which I have submitted before them. They have addressed me the last.
Where is the
communication-
last extension? Show
Yes,
the last.
I'll show Millard. Millard, allow me a minute. Allow me 5 seconds. I'll just place.
That is their manner. We gave the time up to 12th of February and they sent the affidavit, manner. It is fact matter. On 9th of February, they sent the affidavit. But that will perhaps not improve this case.
12th of
So,
February?
The time was given up to 12th of February.
No, this is after.
270.
This is after the result.
Yeah, always. After the date, yes. That will not improve his case, but so for the fact is.
That is after you have already been categorized in a particular result.
No, Millard, the deadline for submitting the certificate, the document which will crystallize my status as a EWS was subsequent. Prior to that, Millard, I submitted the affidavit and explained them my difficulty. Millard,
No, sir.
Millard, kindly see the date.
They-
Millard, once. Kindly see the date.
the last date may be till 12/2, but the
Yes,
point is till the date of publication of result, you never raised this issue.
No, because the occasion did not arise.
How it did not arise? There was one extension
Kindly-
already
kindly-
granted.
kindly-
What are you
kindly-
saying?
Kindly hear me, Millard. Because in the first round, in the written test, Millard, they have themselves treated me as a general category candidate.
Where's the question of treating you?
They have categorized me as a general category.
They have
candidate,
not
EWS.
categorized you anything. They have only published the result based on merit. There is no question of categorization.
No, Millard, kindly seize the first round result.
Sir, everybody's result is published as per merit. Only if they fail in merit, the question of resorting to reservation will arise.
Right.
As per merit, you have come in the written
Right.
test. Where is the question of categorizing you?
No, Millard, kindly, Millard, take 61 once, Millard. Kindly take the 61
There's no
once.
question of categorization.
Millard, this Millard, Honorable Single Judge Millard heavily relied upon this. Millard, kindly, even the Honorable Division Bench while rejecting their stay. Millard, kindly see, Millard, in between, Millard, 7th from the top is my name. Category under which the candidate
Page
applied.
61.
Page 61. Page 61.
That was very.
Sir, please allow. me
Please,
to-
this is not the way. For everything you are standing up. What is this?
I'm sorry.
Yes.
Page 61.
We can't. Yes, Saurabh Roy.
Yes, Saurabh Roy. Millard, kindly see category under which the candidate applied, EWS.
Yes.
Category under which candidate considered
Obviously.
unreserved.
That means nothing. You know very well.
No, Millard,
All reserved category candidates will be treated as unreserved against the unreserved vacancy on merit.
Vacancy.
On merit.
right,
There's nothing unique.
right. Now, Millard, once the final result came, they treated me as a EWS
They
candidate.
did not.
They could not rather.
They did not treat you as unreserved.
They
they
did
were-
not treat me as unreserved. They treated me as a EWS candidate.
Correct.
Candidate, right.
They treated you as they accepted your claim
Claim.
which you failed to
which I failed to establish.
establish.
Now, my lord, I asked this to myself, my lord, what would be the consequence? Had
That is the only thing that has to be seen.
Right. Now, my
That
lord,
has to be
had I-
determined from the terms of the advertisement
terms of the advertisement, now your lordship
and
on
the
the last
recruitment
occasion,
process
on
or the
last-
rules,
on
whichever
the
is there.
rules. On the last occasion, your lordship had pointed out a clause on which, my lord, I also relied subsequently. My lord, I'll just read that clause once again for your lordship. My lord,
Which
put
page?
mine. I'll just place, my lord. The question of, my lord, option that is not applicable, my lord, page 236. For so far as, my lord, reservations are concerned, page 236. Clause 7. Option should be exercised by the candidates carefully after going through the advertisement and keeping in view fulfillment of eligibility conditions, educational qualification, experience, etc. prescribed for the posts. Option once exercised shall be final and no change will be allowed under any circumstances. Millard, the way I read it, Millard, clause 7 only deals with the fundamental conditions to the recruitment. That is, Millard, eligibility criteria, educational qualification, experience. This probably will not be applicable, Millard, insofar as my category is concerned.
And how these three parameters can be subject to a exercise of option?
Well, Millard, because there are several posts, grade 3, grade 2, grade 1, other technical posts.
So the post advertised.
Post
You are saying that
advertisement.
this
Once I, with my
and there is a provision that you have to opt for a particular post.
opt for a particular post.
Where is that shows?
Millard, kindly sees, Millard, the genesis of the Millard, page 219. Millard would find the series of posts for which advertisement was made. 219.
Yes.
Right from civil engineering till Millard would find AG3. And Millard, for other zones, there were even more posts. So one was zone, one was post. So once I make an application,
Where is the provision for exercising an option for the post?
Millard, the advertisement says, Millard, somewhere that only one post I can apply for.
That is what we are asking you to show
Yes,
us.
yes, Millard, I have seen it, Millard. Millard would take page 225. Page 225. Note Roman 1 and 2 in caps. Can apply in any one zone and then for any one of the post code A, B, C, D, E, F, G, H, I within the zone. Now, Millard, so far as EWS vacancies are concerned, it is only one paragraph which is, Millard, explicit in the advertisement, that is at page 223, which your lordship has seen earlier. Millard, I'll just place once again, Millard, for my satisfaction.
Yes.
Millard, if Millard, kindly Millard reads it the way I look at it, Millard, it does not speak of any consequence. It only contemplates one consequence, that is, third line. If the verification reveals that,
Please read.
yeah, I'll read, Millard. EWS vacancies are tentative and subject to further directives of Government of India and outcome of any litigation. The appointment is provisional and is subject to the income and asset certificate being verified through the proper channels. Now, Millard, the consequence. If the verification reveals that the claim to belong to EWS is fake, false, the services will be terminated forthwith without assigning any further reasons and without prejudice to such further action as may be taken under the provisions of the Indian Penal Code for production of fake, false certificate. The income and asset certificate issued by any one of the authorities mentioned in the prescribed format as given in Annex C shall only be accepted as proof of candidate's claim as belonging to EWS. Now, let the consequence has been contemplated.
Where is C?
Let it's Annex C to the advertisement. Millard would find it at page 253. So let me due humility, Millard, I only submit this, that Millard, the only consequence contemplated in the advertisement is for submission of a fake and false certificate, which is again, Millard, a general principle of law.
Where was clause 7?
Yes,
Page 236.
236, Millard. 36.
That EWS provision that you were reading?
Millard, 223, the first paragraph.
So according to you, this provides the consequence for fake false certificate and nothing else.
Nothing else. Now, Millard, kindly, Millard, I'll rely upon Millard one judgment of the Supreme Court, Millard, just 3 paragraphs.
No, but does it say anything that?
Nothing, Millard, nothing. I could.
The advertisement, does it anywhere say how a person claiming reservation is to be treated if he fails to?
Not a single line, Millard.
Nothing is
Millard,
there.
I have meticulously gone through it, not a single line. Therefore, Millard, the general rule will or Millard, I would say, Millard, it has to prevail. Millard, second. Oh, Millard, one set is marked, Millard, that is my set. Or OC lekha.
Ah, this one.
I am sorry, Millard. Millard would straight away take para 12. Para 12, Millard. It could thus be seen.
Just
Yes, Millard.
so this is same as 811.
811. So, Millard, this has discouraged.
Meritorious reserved candidates.
Is right. Right.
Meritorious and reserved,
Yes.
both.
Both.
You are not a reserved candidate.
No,
You never could become a reserved candidate.
I cannot.
You never became a reserved
So,
candidate.
Millard, I has to be treated as an unreserved category candidate.
That is your case, yes, that is your case.
And Millard, the Honorable Supreme Court has Millard deprecated this compartmentalization.
Oh, yes.
And
You need not argue that issue. You
Millard,
need not argue that issue is, there's so many times it has been stated.
Yes.
One-way migration is permissible, merit must prevail. These are very well-established concepts.
Number.
You need not labor on this point. The
Millard,
point is a person who is a defaulter, how he is to be treated. That is the only thing.
The notification is silent, Millard.
So therefore,
Millard, he has to be.
he has to
treated
be
as
given a premium for his default.
Not premium. I'm not asking for any premium.
You
Millard.
are.
No, Millard. I am
You
not
are.
asking for any premium. I am only saying, Millard, kindly also, Millard, the Honorable Coordinate Bench, while dismissing the stay, has noted this.
That means nothing. That is a
prima facie view.
That's nothing.
But it has, the Honorable Court has taken note of this, that I have not taken advantage out of my claim. Neither
What do you
in
mean
terms
not
of
taken
age,
advantage of your claim?
not in terms of age, not in terms of any relaxation.
Very nice. So let everyone apply as a reserved category.
Cannot.
And everyone who fails, they will now say, put me here and put me there.
No.
And those who have bona fide approached the recruitment process, they will all
No, Millard, kindly see, Millard, there is no question of malafide approach.
This,
Millard, I have,
it is apparent case.
Millard, I on the apprehension,
If
Millard,
no malafide, then at least your claim is not established, at
Millard,
least.
Millard, my
You have not
anticipation,
established your
Millard, my
claim.
anticipation was that I could procure a certificate under the EWS category.
We don't know
I
what
failed.
your anticipation
Millard,
was.
does that, Millard, wipe out my performance?
It
in merit?
sure does. It wipes out your candidature. There is no question. The question of merit will come later. That's what we are asking you again and
Millard,
again.
the general principle
The
is
candidature itself will get obliterated if you have falsely claimed
No,
a
I have not
category.
falsely claimed, Millard, I failed to submit
We
the
don't know,
certificate.
we'll go through the entire advertisement.
Millard, kindly,
You
Millard,
are
Millard,
saying
kindly
that there is
does-
no provision.
There's no provision.
We don't.
There's no provision.
So
The
this
only
must be
consequence is
conducted under the rules.
Millard, under the rules of the DOPT, which that circular, Millard, the DOPT, Millard deals with the EWS
No,
reservation.
we are not talking about reservation.
No, there is no specific service rules, unlike
No.
Millard civil services and other recruitments, which is
There is
governed by
no
rules.
rule.
No
There
statutory
must be a
rules.
recruitment rule.
No, Millard, they might have, but the notification
be.
does not specify. I cannot find out.
There's such a long advertisement which has to go through the entire thing. It's a long advertisement. Very
Millard, and Millard, my only Millard submission, Millard, which your lordship may appreciate this, Millard,
starts from page 110.
110. Millard, the clean copy is from 219. 219 and Millard, it runs up to Millard.
Yes, this is a better copy.
Yes, this is a better copy. Two six three is the last page.
There is no difference between these two.
No difference. The earlier one, the Millard, is slightly illegible, Millard. This is a clean copy. This was annexed by them in their opposition. And for once, if Millard kindly considers my affidavit, Millard, what I had written there, page 270.
Yes.
Now, my lord, under the same parent authority, that is the DOPT, and on the same time, my lord would find another notification that is at page 112.
You were trying to show us some affidavit.
Yes. Now, my lord, before that, my lord, I'll just place this. My lord, in other notifications under the same DOPT, my lord, this position has been clarified. My lord, kindly takes the combined graduate level examination 2020, same time. My lord would consider page 132. Page 132, my lord. Paragraph 6.1. If I may just read for your lordship, candidates who wish to be considered against reserved vacancies or seek age relaxation must submit requisite certificate from the competent authority in the prescribed format when such certificates are sought by concerned regional officers at the time of skill test document verification. Otherwise, their claim for SC, ST, OBC, EWS, PWD, ESM category will not be entertained and their candidature application will be considered under the unreserved relevant category.
This is at the time of skill test.
Yes.
This is prior to preparation of the result.
No, no, Millet.
What you want is now result is prepared. I have failed. Now put me in that result.
No, no.
I don't want to be here.
For document verification.
Yes, this
For
is all
document
prior to
verification.
result. This is not after the result.
No, no. After the result, Millet, the document verification is undertaken. Millet, here that has happened.
We don't know what is the recruitment process. Let us see.
Yes, Millet, kindly sees. Millet, my advertisement, Millet, the
No, this clause you are referring to
yes.
is in a recruitment process. What is the procedure? At which stage the document is verified? After the final result? Cannot be. Let's see.
Yes, Millet.
Let's see.
Millet, here in my recruitment process, Millet.
Sir, you are
after-
referring to a clause from an
Yes,
advertisement.
yes.
Don't make a superficial reference.
No, 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 Millet. I won't, Millet.
Please show us what is the process.
Yes, Millet.
And at which stage the document verification is done in that recruitment process.
Yes, yes.
Don't just refer a clause and jump to the next point. The procedure must be there when the document verification is done. Can't be after the result. Otherwise, there will be no result. If everything is fluid, there can be no result.
Millet, so far as Millet, central government recruitment, even state government, Millet, documents are verified after Millet, the interview and the final list is published.
Where is the process? There must be a clause giving the procedure for a recruitment. When the skill test is done, when the verification is done, at what stage,
Millet, the chronological process, Millet, is
has to be there. Cannot be no advertisement without such a process. It's a two-tier examination.
that's right.
Yes. You have not annexed the entire advertisement, cannot be relied upon. It's part. It abruptly ends at page 136. That's
Milord,
not the end of the
I
advert.
have seen that, Milord.
Yes. So therefore, this cannot be relied upon.
Now, Milord, the affidavit, Milord, if Milord takes page 270,
What affidavit?
Milord, the affidavit which I had submitted to them, Milord, prior to the cutoff date,
Yes.
Milord, would take page 271. That due to COVID-19 pandemic situation, I could not obtain EWS certificate within specific time. That in this regard, refer the DOPT Government of India OM number so and so, point number so and so. In case of direct recruitment, and SC, ST, OBC, WS cannot be denied, who are selected on the same standard as applicable to general candidates shall be treated as own merit candidates. That I did not avail any relaxation in phase 1 examination also, so my candidature cannot be cancelled for unreserved category and may be considered in unreserved waiting list as per my own merit in phase 2 examination, as I don't want any reservation benefits in phase 2 examination for selection.
Yes, and this OM is on record.
Yes, this is on record.
Where is that?
Millard, I have placed that on the last occasion, Millard. That is, Millard, that 118 I relied upon. Millard, it starts at 115.
This will be those reserved category can go to the general on based on merit.
Yes.
It's the same as 811
Clause.
and
clause-
this other judgment
clause-
that you are
clause-
giving.
Clause 7. Clause 7. Now, Millard, my only case, Millard, had I been treated as a general category candidate, my rank in the wait list would have been serial number
That we have
7 or 8.
understood what you're trying to say.
Up to 56 they have
Now, after the
recruited.
second opportunity was granted, you saw that you would find a place anyway. Then you said, I will not submit the certificate.
Yes, but I did not submit any false or fake certificate.
You
earlier.
submitted a false declaration in your online application form that you were a
Probab-
EWS candidate.
Millard,
That is an
probably-
admitted
No,
position.
Millard, probably.
Not probably, that is an admitted position.
Millard,
There is no dispute on that.
No, I'm
from
not
your
disputing
side.
that. I'm not
Yes.
disputing them. I'm only disputing this to the extent that, Millard, unlike SC, ST, OBC, which is, Millard, a category, Millard, which has its genesis on my birth, at times except the criminal and non-criminal criteria. But EWS, Millard, I was relying on DVA also, Millard, the 2024 Supreme Court decision. While the Supreme Court explains that it is a status which only crystallizes upon obtaining the certificate. And they themselves in the notification said EWC vacancy.
And how does that help you?
But it helps me to the extent that since.
So every EWS,
Fairly,
so according, if your submission is accepted,
yes.
in every recruitment process, all unreserved category candidates will apply as EWS. If I get the certificate, I will avail, otherwise I will not avail.
But probably
Can that be
probably
the preposterous submission?
Probably
This is a preposterous submission.
No, Millard.
You are expected to know whether you are an EWS candidate when you apply. It cannot be in the realm of a speculation like this.
No, Millard, EWS
What is
category.
this?
Millard, EWS category.
It is subject to availability of or obtaining the certificate. There you are correct.
Yes.
Unlike the other three where it is by birth, irrespective of the fact, that's why we said Ram Kumar Girjaroya will not apply to your case.
No, I'm not.
The judgment of the apex court
Yes,
in
yes,
that
definitely.
case,
I'm not
it
relying on
says
that.
reserved categories. Under these three categories, they will remain a reserved category whether they have the certificate or not. For you, you claim it because you say in that year I was economically weaker. I will give the certificate. And then you say now I can't give the certificate.
Now,
It
Milord,
is-
now, Milord,
You have claimed that category.
Milord, the
You
Supreme
have
Court
asserted a
judgment-
claim to that
Milord,
category in
I-
your
I
application.
would say, Milord, it's a claim. Milord, it's a category
You
in
can
which
say
I have,
anything,
in which I have applied.
But these issues are not open to argument. It is very well settled. When you make an application claiming a particular category, it is your representation and you have to
Correct,
live by it.
Correct. And the consequence.
Yes,
If I
and
have-
if there is any consequence, it will apply, otherwise it will not.
Yes.
According to you, there is
Yes.
no
There
consequence.
is no consequence contemplated in the advertisement.
That you have said.
So therefore, Milord, I ought to be treated as a general category candidate. And Milord, since you have selected candidates
Yes.
up to Milord marks which are lower than me, merit cannot be washed out, Milord, only because of the fact that I have not submitted.
So
the
therefore, that we will consider. That 811 you have already said. So you say there is no consequences specified. Come to page 237.
Clause 11.
Please, sir, what is this? Every time you have to stand up and say something. You were arguing for so long, he did not say anything. What is it? You have some privilege that you can interject whenever you want. Clause 11 at page 237.
Yes. Milord, I have.
And then 247, there is a
Milord,
box.
Milord, with deepest respect, Milord, I would submit.
You
Milord,
did
this
not,
is-
you did not point this out. We asked
No.
you so many times.
No, no, Milord,
What
this
is
does
the
not-
provision?
Milord, this, Milord, kindly sees
You
what.
could have pointed out and then said whether it was covering you or not, but you did not.
Milord, so far as EWS is concerned, Milord,
Very well.
with deepest respect, Milord, it does not
You
contemplate.
could have said that. You should have pointed it out. We asked you.
Milord,
You said,
kindly-
I have gone through the entire advertisement. There is nothing.
Marked. It is marked. It is marked in my copy.
You
Milord,
should
in
have
my
placed
brief.
it. You should have
Milord, in
placed it.
my understanding, Milord, it
You
does
should
not.
have placed it, sir.
Milord, in my.
We asked you twice and thrice
Milord, in my
whether
humble understanding,
consequences
Milord,
are contemplated or not. You did not place it.
Milord, kindly sees, Milord,
All right,
what
so
it
this
says.
doesn't apply according to you. There's no question of looking into it.
The
You did not
candidate-
place this.
Candidate who does not fulfill the eligibility norms.
All right. Very well.
Eligibility norms stipulated in the
You
advertisement.
did not place this. Yes, that's all then.
Milord, and page 241, Milord.
You did not place this. We were expecting you to place this. We asked you so many times.
Did not place this, Milord. I felt
According
that
to you, it doesn't apply.
and,
Yeah, according to you, you
Milord,
go
not
only,
able to furnish a
you are
evidence.
only going by what that one provision, clause 7. That applies to option for another thing. That's all.
Yes.
That's
Yes.
yes. Now,
So that I was about to highlight, my lord, and so far the option clause is there, my lord, that would be very narrow, my lord, interpretation. If option is to be applied only for the purpose of post and.
no,
not-
that prima
status.
facie we are of the view that he is correct regarding clause 7.
It is been
That is,
option. So option, my lord, eligibility criteria is also an option. And eligibility criteria may be as regards his status.
maybe
and
not,
legacy.
maybe not. It doesn't appear.
And my lord, apart from my lord, that particular clause 11, if my lord kindly comes to 241,
Yes.
there also my lord, clause number 26. Before that, my lord, 240.
26.
I'm sorry, my lord, 240, my lord, clause number 18. Shortlisting in the online test and skill test for any post without fulfillment of eligibility conditions will not confer any claim to the candidate for final selection to the post.
Yes.
And that apart, my lord, if my lord kindly comes.
Now you are repeating all this you have placed. Don't re-argue
My
your
lord,
case.
That is the thing, my lord. So-
Anything we have said you want to reply, then you
Reply
tell.
with that my clause 11 specifically deals with the cancellation of candidature. And my lord, so far the declaration is concerned, my lord, you have highlighted that the declaration has to be in his own writing within a specific format.
All that you have placed. On the first day you have placed.
And I was carrying one decision, if my lord allow, though it is settled position, recruitment process, my lord, can be changed only if, my lord, there is a provision for it. So there is a certain, my lord,
Where is the question of change of the recruitment process? You are arguing something which does not arise at all.
But if we allow his claim, my lord, then it amounts to, perhaps in my understanding, it amounts to change the process, because we can cancel once the, my lord, the document verification is done. That is all, my lord.
Yes. Very well. Heard the parties. CAV. Next.
Item number 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15,
15, your lordship, I'm praying for next circuit.
As prayed.
16, 17, 18,
Okay, your lordship, I'm praying for next circuit.
18.
Yes.
18.
Your respondent will not allow your prayer. Not today.
Gratefully, lordship.
19,
19 and 20, my lord, last occasion matter was taken. I am led by Mr. Devashish Kundu, he is on live.
All parties are here. There is a resolution. We have been communicated. There is an election.
My lord. That being position, my lord. It's very cute. Come, yes, my lord. Yes, we have to.
President and secretary came and told us that since there is an election, if somebody does not appear, please don't take up.
My lord, I appear for the appellant.
You are muted.
Not,
Yes,
am I?
now okay. Yes.
on last Wednesday, your lordship was pleased to hear the matter at length, and thereafter, my lord, the learned advocate
Hear it
appearing
at
in the
length, we had a bird's eye view of what is going on. We
very
did
well.
not hear it.
Well, I'll be ready to start again.
But
And
then,
then,
no, the issue is whether non-production of a receipt showing payment
yes,
can be made the basis of denying the subsidy. That is all.
yes. That's
The
the
other
only
side
thing.
is not here, and there is a resolution that there is an election today in the bar, not to take up matters in which both sides are not present. So therefore, we are asking your assisting counsel that tomorrow we can continue.
Very well, then that will not let the matter remain in the list.
Not today. Not
It
today.
remains position.
Yes, not today.
I'm
Same position. Today nobody is there.
but Mr. Bodman is here.
He was not here when it was called.
Your lordship will fix the matter at 2 p.m. I shall. Nothing and I am coming. Your lordship knows. Last occasion, last Wednesday, my lord, I am fixing that.
If he is here, you mention at 2 p.m. Don't worry. If he is here, you mention at 2 p.m. Call the list.
Item number 21.
Yes.
22.
Yes.
23. 24, 25, 26, 27, 28, 29, 30, 31.
31, my lord, my appeal, admission of second appeal. My lord was pleased to hear it on day before yesterday. The only point which whether section 34 of the specific relief act will be a bar in my case, where my lord there is in the plain case, my lord, I said that I am in possession.
Yes, you have come with the judgments.
Yes, my lord.
Very good. So, he has also said.
On the point of limitation, my lord, I am relying on order 41 rule 3A. That the appeal was not accompanied by a application for condonation of delay, my lord. Order 41 rule 3A. My lords are there. May I place it, my lord? When an appeal is presented after the expiry of the period of limitation specified thereof, it shall be accompanied by an application supported by affidavit setting forth the facts on which the appellant relies to satisfy the court that he had sufficient cause for not preferring the appeal within such period. If the court sees no reason to reject the application without the issue of a notice to the respondent, notice therefore shall be issued to the respondent and the matter shall be finally decided by the court before it proceeds to deal with the appeal under Rule 11 or Rule 13 as the case may be. Where an application has been made under Sub-Rule 1, the court shall not make an order for the stay of the execution of the decree against which the appeal is proposed to be filed so long as the court does not, after hearing under Rule 11, decide to hear the appeal. So, my lord, admitted position, my lord, no application for condonation of delay was made. Consequence, my lord, then it was barred by limitation, it could not have been heard. That is what my understanding is. It shall be filed. The word shall has been used, my lord. Yes. May I make one humble submission, my lord? My lord, can let formulates the point of law on this, let them come and fight it out that there is a consequence. I am, my lord, submitting that since the word shall has been used, it is mandatory. If that has not been complied with, the appeal could not have been heard. The defect remains, my lord. The appeal is defective. I have, my lord. I have, my lord. No. My lord, kindly, I have said. Yes. Yes, my lord. I was only on 43, my lord, 41.38. Let me come to on the limitation. Well, yes. Father. Yes. Yes, my lord. Yes. Yes. And my deed of gift is also there. No, my father gave it to me. My father was the actual owner. Yes. Yes, my lord. Yes. My lord, on. Yes. The Akamma's judgment, my lord, is in my favor. With. Yes, it says, my lord, that declarative, if I am praying for a declaration and consequential relief of injunction, that satisfy the proviso of section 34. If in the plaint, my lord, I have the plaint case is that I am in possession and I have prayed for declaration of title. No, my lord, plaint case is my possession. Here in the cross-examination, I have said that my father had given, I do not know whether the possession was taken back from me. My plaint, my lord, has specifically said that it is in my possession. And my lord, can you take up the plaint, paragraph 3, my lord, at page 33. Page 33, the plaint starts. Page 35, my lord, kindly see the last line of paragraph 3. That's stood in the physical possession of the plaint and it was free from dispute. That is, my lord, I had my lord, of the application for stay, can 2. Thirty-four, my lord, paragraph 3. That when the plaintiff, my lords are there, that when the plaintiff wanted to dispose of certain prior portions of her land falling within the Schedule A property and intending purchasers, the defendant precluded the plaintiff from doing so and stating they would not allow such and such, my lord. Even earlier, here, my lord, what has happened, I had made these submissions on the basis of those documents, which subsequently, my lord, the learned court did not take into account. The report of the BLRO, which says that I am in possession. But here, my lord, my specific pleading that I am in possession, my lord. Then paragraph 4, my lord, that recently the defendants who last line, my lord, last lines. Then, my lord, paragraph 4, that recently the defendants who have no concern whatsoever with the Schedule A property 29/7/19 has started interference in the peaceful possession of the plaintiff. Then paragraph 5, I have said, my lord, the defendants are utter strangers with respect to Schedule B, a property devoid of any right, title, interest, and much less possession over the Schedule B property. The defendants are creating nuisance by attempting to trespass on to it with the help of miscreants and formed illegal associations of persons, thereby illegally attempting to interfere with the plaintiff's peaceful possession and enjoyment of the Schedule B property. In respect of there are three issues. One is another representative capacity, order 1, rule 8. In the deposition, my lord, defendant one says that I am in a representative capacity. But under order 1, rule 8, my lord, no leave of the learned court was taken. There again, my lord, a question might come that what happens if does not take. To that, my lord, I don't have any answer right now. Yes. My lord, kindly takes up my memorandum, my lord. My lord, ground 1, whether the learned first appellate court out both in law and facts and failing to appreciate that the first appeal was barred by limitation. Second, also, my lord, similar, whether the learned first appellate court was, sorry, my lord, both in law and facts by hearing the first appeal, even after the first appellate court. Yes. But that has been specifically not mentioned, my lord. Yes, I know that. My lord. Come back. My lord. I will. Yes, sir. There is a requirement of the that the case appeal was required to be accompanied by an application. 41 rule 3. Yes, my lord. Yes, my lord. Yes. Yes, my lord. So far as the thing that the appellate court has overlooked. By the instance of the appellate court, when there is no case. Yes, my lord. Yes. What has been said in a Samaj. Yes, my lord. So we pointed out that. Yes, my lord. Yes. You must suggest. And there is another question that may be only there in. Yes, but I will come back tomorrow. Lordship, I will come back. Grateful, my lords. No, not for the register. Yes, my lord. 10-2. Because the first appellate court held that my possession is not very clear, my lord. Yes, I am. But the first appellate. Madam, I have. No, Madam, prayed for stay of the first appellate court, sir.
Look, 21, 22, 23, call the list fast, after rises, 21, 22, 23, on the insistence of the Union of India, it was specifically kept today by the Mr. Singhania. That RPF rules, 151 and 54, observe, then would consider the scope of 154 of the RPF rules.
Milord, with regard to item number 30.
have only 2 more days. I don't want to carry one. So whatever we can do.
Milord, with regards to item number 33. Milord.
Not what we have.
Yeah, call.
We have.
Someone told me that he will be present at 2:30 regarding item number 13 and 14. My lord, he's engaged in, my lord, some personal kind.
32, my lord, I am appearing on behalf of the petitioner led by Mr. Sandeep Prasad. He is appearing virtually, my lord. The first appeal, my lord. Can 1 was allowed, my lord, on the last occasion, and it's fixed for can 2, hearing of can 2, my lord. Section 5 was allowed.
Lordship, I am for the appellant in this appeal. Lordship.
Section 5 has been allowed.
Yes, my lord.
So what
Lordship,
is,
this section,
yes,
Lordship, the section 5 has been allowed.
Yes.
I am on the, Lordship, the can 2 application. Lordship, we have filed this can 2 application for the appropriate order. So far as this appeal is concerned, Lordship, we are the appellants are
so
the
notice
plaintiff
has to
before
be
the court.
issued. Notice and TCR.
Lordship, the
This is the affidavit of service we have served upon all the respondents, my lord.
Lordship, the can 2 application has also been served. On earlier occasion, at the time of hearing of a can 1 application, the respondent didn't turn up. Lordship, today, Lordship, the can 2 application is to be disposed of, Lordship, at least the status quo order, because the suit is pertaining to the partition suit, declaration, injunction, along with the consequential benefits.
Yes, we'll just issue notice and call for the records.
Lordship.
Yes.
That notice be issued upon the respondent. Full stop. And the record of the trial court. A call court. Full stop. Who will bear the cost? Special messenger cost will bear.
Lordship.
You have to deposit the special messenger cost within a week.
Lordship, we are agree on.
The learned counsel representing the appellants submits that.
Lordship, only one indulgence.
What?
The Lordship, with regard to the can 2, Lordship, can it be the status quo order in that because it's a suit for partition? If
When
they
the
will go on-
impugned judgment has been passed.
Lordship, it has been passed in the year of 30th of January
23.
2023.
When did you file the appeal?
Lordship, it's after 336 days.
What is this? You want a status quo? Yes.
The representing the appellants submits that special messenger cost will be borne by the appellant. In such circumstance, let the cost of special messenger be deposited within a week from this date. On deposition of the cost of special messenger, department is directed to call for the record. Take steps immediately. Department is directed to take steps immediately, and on receipt of the record, after verification, if it is found to be in order, learned counsel representing the appellants be informed. First of, and notice be sent immediately upon the respondents. That the trial court record is in order, then after we prepare the proposal. After receiving information as regards to the trial court record being in order, the appellants are directed to prepare the informal paper books, requisite number of informal paper books within 4 weeks from that date.
Affidavit of service be kept to the record.
Can two for appropriate order stands disposed of. Yes.
I'm grateful. I'm grateful.
Yes.
The 33, I don't know, the 60 of the article council is from delivery got paying for not.
Not.
34.
Yes, it's a notice of the.
No damage, no backward.
Not something.
No, no.
One of the both sides are here. Since the respondent has submitted that there is possibility of the applicant explored that option. Now.
Oh, excluding that 3 because.
Yes.
Excluding some.
Now he doesn't want to take the land. He wants the refund. So we agreed to that he has paid only 11 lakhs out of 15 crore something. So we agreed to. Now he says, no, I will take 50 lakhs. Okay, on a piece of document that is money received, he has obtained the injunction order now. And now he's asking for 50 lakhs. We said we agreed to pay.
This appeal against the injunction order.
Against the order, against the order passed under order rule 9, rule 39, order 39, rule 4.
Oh.
I paid for vacating the interim order because they have obtained this interim order on the strength of a manufactured agreement. One page agreement, if you it's not the formal agreement. In this code, although they have said that they have drafted.
Can this issue be decided at this stage?
The thing is that they are enjoying the interim order. They don't want to take the land.
Whatever it is.
It
can only be decided when the appeal is heard out, not at the stage of order 39 rule 4.
Kindly sees the document forwards. But the page 57 now, kindly sees. This is the money receipt.
That's why we are asking you, can we?
Yes, I'm willing to.
At this stage, can this court?
I am willing to refund the amount. Is that 11 lakh?
You have said, that you have said. That you have said.
First of all, just figure out.
When we ask you, you say yes. And now when we proceed, then somebody else has to appear. Have some decency. Not today. We asked you before taking up. Both sides are here. You said yes. And now when he has made his submission, Mr. So-and-so has to appear. We don't know what you intend to do. Call the next case.
Number 35.
Call.
36. 37. 38. 39. 40.
Respondent only.
I'm for the applicant. But state was the respondent, but I don't know the applicant.
Not to. Next.
41. But then I'm for the applicant. I'm for the 42. 43. 44. 44 versus I'm for the petitioner.
Petitioner, what is it?
It's pertains to the instrument and I especially appeal against equitable. There is a delay of 108 days, so there was a directional service upon the opposite party as delivered.
Here we call you to not give us.
My grandma is application for condemnation of.
Hmm.
Because it has. Oh, that's reached. 24.
Yeah, affidavit of service is filed. Wherein it is, wherein the tracking report reveals.
Number 45. That's right. This is illegal services provision.
Not today, come with 2 copies.
46, 47.
For the respondent.
46 respondent. Wakalatnama has been filed along with the caveat. Get the wakalatnama. Let it come tomorrow, not today. File it. Details लेके वकालतनामा मंगवा लो. Let her get it tomorrow. Ask them to get the wakalatnama.
That is number 47. 45, 48.
48 doesn't respond for a for the.
Both sides are.
Yes.
No, we are asking you both sides are present.
Yes, both sides.
Replies to be filed.
Not required.
So we can proceed.
We can proceed.
Something elaborate or?
Not a heavy matter.
And you have 2 more days, therefore we are asking.
According to me, but
Let us see what.
this is against Millet and order passed by the taxation tribunal.
Yes.
Now, before looking at the impugned order, I'll just tell you, Lordship Millet, for the financial year 12-13, there was an assessment order passed under demand of about 2.73 crores. So there's against me. I am
Under GST.
under the WB VAT Act.
Okay.
Old.
Erstwhile.
As
Prior to 17.
Yes, that is. This is for the financial year 12-13. I am against me, I am a public sector company, the National Hydel Corporation, NHPC. Subsequent to that order, within time, we had preferred a review, which is stipulated under the Act. once an adjudication order is passed, there is a provision for review. We preferred a review, and according to us, the statutory fees for preferring that review, that was also deposited by way of a challan. Now, once the review was filed, the respondent number 4, that is the sales tax officer, was also intimated that we have preferred the review, and that communication is also on record. We requested him not to proceed further till the pendency of the review. Now, till 15 to 2022, we do not receive any communication from them. Neither any intimation of the proceedings, nor any notice, no communication from their office. All of a sudden, on 2nd February 2022, we receive a communication asking us to pay the amount. And there, in that email, they annex 2 documents saying that our review has been rejected on the ground of non-payment of statutory fees, that is 100 or 200 rupees, which according to us, we had already paid by our challan. The challan is before the lordship, it's there on it. Now that rejection of review, that communication we received on 2nd May. On 22nd February, immediately thereafter, we requested them by way of a communication that kindly provide us an order of the review, since we have to take recourse to the accordingly. The copy was supplied.
So after 9 months, not immediately, after 9 months.
No, the communication was 2nd of February. We made the request on 28th of February.
Oh.
So after 26 days.
What are you saying about May?
I'm sorry, that was a slip of tongue, that rejection was communicated on 2nd of
February, not May.
February, not May. I'm sorry. We requested on 22nd February. The copy was supplied to us on 12th of April 2022. That copy was certified on 12th of April 2022, but from that order it appeared that the rejection happened on 27th of August 2015, I'm sorry. So against that order, we went under section 8 before the tribunal for setting aside of the order. Now,
Review order.
The rejection of the review.
The order passed on the review.
Now, the honorable tribunal rejected my application on the ground that since copy of the rejection is annexed to the application, we cannot plead ignorance of the order. That was the ground on which my application was rejected. Now, the copy, how we received it was pursuant first, a copy of the order, uncertified copy by way of the email in 2022. Thereafter, the certified copy, subsequently, when we asked for the copy that is in 22nd of February, which was supplied to me in April. Now, this fact was not correctly portrayed before the learned tribunal, and according to us, the learned tribunal misdirected itself in rejecting my application of seeking revocation of the order of review. This is the genesis of the case. Now, could kindly take the impugned order.
So the review was rejected the very next day when you filed it.
Yes, the very next day it was filed.
And you don't know that.
We do not know, though they have annexed the order of rejection, whether that was supplied to us, that they have not annexed in their opposition.
So there is a requirement of supplying the order.
It has to be communicated or intimated.
No. What is the requirement under the Act and rules?
No.
You are the person who has invoked the review jurisdiction.
Correct.
It's not that you are the defendant or respondent that you can say, I don't know what is going on.
Yes.
So today you file it, tomorrow they say it is not in accordance with law, they reject it. Now you say it was not communicated for 7 years. And you were also not bothered what was happening for 7 years.
Yes.
This is your plea. So where is the requirement of serving a copy, communicating it to the applicant or review petitioner? Let's see the rules.
I think the rules similar.
They have the order review, the review application 27/8/2015. That was passed in 2015. They sat for 7 years and they filed only an application in 2022 seeking a copy of the judgment.
No, I have not filed any application.
You are saying exactly what he said.
Yes.
We asked a very specific query. We thought you would shed some light on that. Is there any procedural requirement of serving? There are many statutes which say order has to be served on the. So is there any such requirement?
Let me come back with the rules.
Let's see.
Tomorrow.
Tomorrow, yes.
Yes, I will come back with the rules. So let us examine this.
There is an obligation cast on many such statutory authorities that
Yes,
they
yes.
must serve a copy.
Right.
So let's see whether there is any such provision.
So also the responsibility on.
Affidavit in opposition filed on behalf of the respondents taken on record. Matter adjourned for the day. What is the, can you please ask someone to give the name of the act? So that.
Elevated tax act 2003.
Get
Elevated tax WB VAT Act.
WB VAT Act.
WB VAT Act 2003 and the rules would be WB VAT rules 2005. So those. Great. Great.
49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65, 56, 57, 58, 59, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89,
is required.
90, 91, 92, 93, 94, 95, 96, 97,
now the 20.
98, 99, 100, 101, 102, 103, 104, 105, 106, 140.
He has not come.
Yes, sir.
So we can take up. Give 13, 14.
So this is creating on some personal ground. Thereafter.
It's a hearing matter.
Yes.
You have filed the report that filed the report when you did so that was filed.
But what happens, but I am saying here,
You are supposed to file exception.
but practically, but you can explain the reports without finding any exception. That's why, my lord, I don't want to file any exception because it is again, my lord, Lingartam. But what happens, my lord, these two petitioners, the 13 and 14, they have been appointed as a teaching cum learning assistant in a government college by way of an walking intern in the year 2008. My lord, I have
In the
annexed
year? In the year?
2008.
What is the post?
Teaching cum learning assistant.
This is in school.
No, college.
Home and
Now,
Teaching cum learning assistant
yes,
in Olema.
yes. But what? But
In which institution we are?
but it is in ABN Seal Government College.
ABNC Government College. Shill. And this appointment was by way of a walk-in interview in which year?
2018.
Yes. So then what happened?
But what happens, my lord, hereafter, they are my lord, working here. By way of their remuneration as per class basis.
As
per class basis. Per class they have been paid.
Yes.
Now, my lord, in the year 2019,
Where is your appointment order?
my lord, that is my lord, your lordship first got the your lordship take the Deepak Vishwas matter. Your lordship take the Deepak Vishwas.
The first matter first?
Oh, yes.
Yes.
Your lordship kindly come to annexure P2, page 47 of the paper.
Paper. 47.
Yes. This is the walk-in interview. Your lordship, right hand column top. Walk-in interview. ABN Seal College. Interview for the post of teaching cum learning assistant and library protect assistant. Data
So
entry
this is a
operator.
private college?
No, my lord. This is a government.
Government.
Now, what happens, my lord? This is these petitioners are.
Where is the appointment order?
My lord, the next page, they have been given appointment. Now,
Yes. Then
my lord, in view of the why I have this petition has been.
so your engagement lapsed in 2019.
No, my lord. Your lordship kindly come to then.
It continued after 19 also.
Yes, my lord. After
It was only for one session, 2018-19 appointment.
Yes. Your lordship kindly thereafter it has been continued. And my lord, your lordship, that I will show your lordship. Your lordship kindly come to on the basis of.
So therefore you continued. Then what happened? What is your grievance?
Your lordship then come to page 58 of that paper. My lord, this notification on my lord 23rd December 2019. On the basis of this, all these persons have been taken in the college as state aided college teacher. They have been categorized in two ways, category 1 and category 2. Your lordship got it from these notifications.
You are placed in which category?
My lord, the first petitioner in category 2 and the second one is category 1. Because my lord, the first petitioner, second petitioner has got the net and slate, and he has also, my lord, to be qualified for a college teacher. That's why. My lord, in this respect, your lordship kindly come to, I am reading the first paragraph of this. The matter of restructuring of service conditions and other benefits for government approved part-time teachers.
We are reading. Please don't worry. We are reading. So the present petitioner is a contractual whole-time teacher
Practically,
under this notification.
present petitioner before present appellant petitioner is only the teacher in education subject at the time when he was appointed in this subject.
Under this memorandum,
Yes, sir.
there are two categories.
They are
Category 2 is known as contractual whole-time teacher and category 1 is known as part-time teacher.
no.
So, what no?
My lord, I'm saying
Don't say anything. Read the memorandum.
the
You
this
come
is-
to clause 3 of the memorandum. Approved PTTs and CWTTs. There are two categories approved under this memorandum. PTTs are those who are category 1 and CWTTs are category 2. So therefore, we are asking you, the present petitioner is a CWTT.
they are, my lord, the under the guest teacher in any nomenclature.
Guest teacher.
Guest teacher in any nomenclature. Your
Oh,
lordship,
Very well.
your lordship kindly come to the first.
All right. So that is your case. They are guest teacher.
No, my lord.
Yes.
My case is in this, on the part of this.
Yes.
My lord, why I am placing this matter?
Yes.
The matter of restructuring of service conditions and other benefits for government approved part-time teachers, government approved contractual whole-time teachers and guest teachers in any nomenclature engage in different government aided colleges in the state of West Bengal up to 13/7/2019 was under active consideration of the state government for some times past. After careful consideration of the matter, the government is hereby pleased in supersession of all previous orders in this regard to restructure the service conditions along with the change of nomenclature of the aforesaid category of teachers commensurate with their qualification and period of service rendered in the following manner. Part-time teachers, contractual whole-time teachers and guest teachers having qualification for being appointed as teachers in the colleges as prescribed by the University Grants
See,
Commission.
this memorandum does not define who is what.
Yes, ma'am.
So you say you are guest teacher. Now let's proceed. What
Yes.
is after
What-
that? What?
What happened?
Yes.
My lord, thereafter, my lord, our name has not been sent as per this memorandum.
Yes.
We
So the
prayed-
benefit of this memorandum was not extended to you.
No, my lord. It has been extended, but there is some confusion. My lord,
It
your
has been
lordship then-
extended by which order? Show us.
No, no, my lord. By this way, by this memorandum, we pray that we should be treated as sacked teacher.
When this benefit has been extended to you, show us from the writ petition which date this 23/12/19 was made applicable to you and by
Madam,
which order?
If your lordship kindly come to that page 58 and thereafter with the memorandum, there is some, my lord, the form is there.
We are asking you a specific query. This 23/12/19, you say it was extended to you. When, by which order and from which date it was extended to you? When did you get this consolidated salary? Which month? Where is that pleading in the writ petition? Show us.
But we are getting class-wise salary.
So
But
you are
we have
not, you
been-
have never got the
we-
benefit of this
my lord,
memorandum.
I am,
We are not asking you
I
what
am-
you want. We are asking
I
you
am-
the factual position.
yes, my lord, factual position is that I am
Yes.
basing on the terms that
We are not asking you what you are pressing. We are asking you, was this memorandum extended to you or not? By any order,
in my way.
not in your
This
way.
is not-
Any
this is not-
order, any order extending the benefit to
This
you
is
or not?
not question of extended. This memorandum will apply to me.
So you are claiming, all right. Now let us see. So it has not been
Your
extended, you are
lordship then
claiming.
come to annexure, your lordship then come to page 50.
Yes. What is page 50?
My lord, this is the certificate of performance given by the
Who is doubting your performance? Who is doubting your
No, no,
performance?
where from your lordship got the criteria. This is the genesis of the case.
Yes.
Page 50.
Page 50.
Yes, ma'am. This is to certify that Sri Deepak Vishwas, such and such, is the teaching cum learning assistant, functionally equivalent to guest teacher, Department of Education, ABN Seal College. He is the first founder teacher of this department. He is appointed on 18/7/2018 due to the fact that at the time of opening this department after having university affiliation and state government approval, no regularized full-time teacher has been posted by the Department of Higher Education, Government of West Bengal. And also at the time of no part-time teacher within the age group of 60 to 65 years is available in this remote place from the capital city of West Bengal. In fact, the department has been opened subject to the condition that regularized full teacher will be posted herein after 2 years opening of the department. Till today, the regularized full-time teacher has yet not been posted. My lord, then your lordship kindly skip the next paragraph and then come to this next third paragraph of the top. See Deepak, your lordship got it. See Deepak Vishwas is
We are not skipping any paragraph. We are reading that paragraph. Yes.
However, Sri Deepak Vishwas has been rendering his intellectual and physical service as teaching cum learning assistant in this head department, ABN Seal College, very much satisfactory without any rate as per record. He has been being remunerated per class basis. The per class remuneration is rupees 150, only increased later on rupees 180 only. His remuneration has been given out of receipt from the collection of Acharya Brojendranath Seal College Parent Teacher Association, which is a recognized trust. This has been found in the year 2016. Following the recommendation of NAC PRT relating to first cycle of NAC visit to the college in the year 2007, the receipt from ABNSC PTA is one of the constituents of the non-government fund of this college. Sri Deepak Vishwas is hereby allowed to continue his service as teaching cum learning assistant in the college for the coming course of time. It is expected that his parent rate of remuneration shall be increased in the near future until he becomes state-aided college teacher. The process of his approval as SAC has been going on in Department of Higher Education Department, Government of West Bengal. In any circumstances, his remuneration can't be stopped, withheld, and also he can't be terminated. To withhold ongoing remuneration and termination of his assignment stroke service will create unimaginable welfare of the college by reducing student and public interest. And simultaneously, this will be very much inhuman, unethical, illegal, unlawful, unconstitutional, not only towards him particularly, but also adjoining society in general. Moreover, his assignment service is extended by the college authority through proper process following the recommendation of the inter-quality assessment cell, such and such, and dense oral communication consultation with the higher authority. The IQAC is the creator of the concept of teaching cum learning assistant, wishing the radiant, loving the concern. Now, your lordship, after this, when the higher education department did not give me the sack, I am filing one writ petition before this honorable court. This honorable court, your lordship kindly come to. Your lordship kindly come to page 99. The first order of this honorable. Lordship got it? Lordship got it?
Yes.
May I read your lordships? The petitioner's allegation is that even though he is entitled to get benefit of memorandum being number such and such dated 23rd December 2019.
So recent order was to be passed.
Yes, ma'am.
Now what
Now-
order has been passed?
After this, my lord, the higher education department rejected my claim, which is, my lord,
That is the subject matter.
110
That is the subject matter of the present petition.
present writ petition. 110 of your lordship.
And where's your representation after the High Court's order?
Court's order.
After the High Court's order, you must have made a representation to them. Because their decision has to be tested in light of what you have claimed. So there was no requirement of filing any representation. The court said since all the documents are with the director, he will take a decision.
Yes.
Yes. So now the writ petition is only regarding the validity and of this order.
Yes.
So what is wrong? Let us see. What is wrong with this order?
Now, my lord, after that I filed a writ petition and the writ petition was rejected. My lord, taking into the similar consideration as well as there is some other reason. The learned trial judge said that the teaching cum learning assistant means the practically the learned judge wants to say that it means that a person who only just sees about the students whether they have been taking the classes and if they have any doubt in respect of the course of the lecturer, they can the doubt clear like that. In that respect, my lord, I filed this appeal before your lordship. Now, while my lord, the appeal is in the final hearing, there is an order before this. There is an order of the coordinate bench of this honorable court on 22nd August 2024. In that order, if your lordship kindly take this bunch of order passed in this appeal. Not I'm giving the two copies, though it is your lordship.
22nd August, we can see what does it order.
Last order is, my lord, the
22nd August 24. 22nd August 24.
yes, my lord. This was question framed by the this honorable court.
Just keep it. Keep it, keep it. So they were required to file a report.
Report, my lord, why, my lord, I am placing this order before your lordship.
Yes.
My lord, the for last, my lord, the appeal was after the filing of the appeal. No one representing the principal. Though, my lord, I have served several times, no one. Suddenly, all my lord, 22nd August 2024, this honorable court directed the college because this honorable court does not believe the report filed by the college before the director of public instruction.
Before the
Director of public instruction.
director
Lordship,
of
kindly see that in the order of the director of public instruction, director of DPI said that the report from the report of the college authority. And as such, this this honorable court direct the department, the principal of the college to file an affidavit, putting some questions to that.
yes.
On the basis of if your lordship kindly go through these questions.
Yes, the judge,
Yes,
the
yes.
division bench wants to see whether the reasons assigned for in respect of your status are tenable or not.
Yes.
So therefore, he has framed certain questions.
Yes.
So then what happened after that?
But this report has been filed probably.
Already filed. So what is the report?
Your lordship kindly go through that one by one.
Dated?
My lord, this is affirmed on, my lord, 4th March 2025.
Respond number 6.
Yes. Respond number 6.
Yes.
Your Lordship got page 3.
Yes, we have it.
Is there any trust or other private body that runs and maintains the college? Since this is a government college, it runs by, maintained by Higher Education Department, Government of India. Is there any managing committee or government body that runs and maintains the college? If so, what is its composition? Directorate, Department of Higher Education, Government of India plans and controls all necessary measures adopted for smooth functioning of this government college. Is there any other private body involved in funding or running the college or participates in the running and funding of the college and taking decision as regards its management? There is no option to private body to involve in running the college. Is the college is a government college or one aided by the government? Acharya Bhojendranath Sil College is a government college. If the college is aided by the government, under what head its aid received from the state by the college and how it is disbursed? As this is a government college, the college received headwise fund from the state and disbursed through treasury. Next page. What are the nature, duties and responsibility of the appellate in the college during his period of engagement as a teaching cum learning assistant? The appellant Deepak Vishwas was teaching cum learning assistant and engaged by the YC Leaden Dr. B.K. Saha through walk-in interview by newspaper advertisement per class basis according to engagement letter during his period of engagement from August 18 to February 21. Leaden YC engaged them as a stopgap local arrangement having no approval from Department of Higher Education, Government of India. As per next question, whether
Yes.
the appellant in fact independently taught the student. This question is very vital. So far regarding the
Yes, they say under the head of department. We have gone through.
yes. As per available record, he taught the students under supervision of the head of
department.
It is a this is a language. Your Lordship knows better than me that under the head of department, all teachers and all professors or lecturers. So, this is not the question.
Please read again. It says the class was under supervision, not that he is working under HOD. The class is under supervision. Please read again.
Yes, madam. Taught the student as an
Under the
instructor.
supervision. That is a word.
Yes, madam. That's why, madam, I am saying.
That all teachers are under the HOD. We have understood what you are trying to say.
No, madam. What happened? Madam taught the students under supervision head of the department. If this is true, madam, your Lordship kindly see the officer in charge of the college who has appointed this petition.
He was the appointing authority.
At that time, he was the appointing authority.
Where? Under which provision? Show us.
On the basis of the.
Please show us. Under which provision he was the appointing authority.
If your Lordship kindly go through all my annexes, your Lordship side will see.
We are not talking about who has appointed you. We said he is the appointing authority. You said
He
yes.
is giving the appointment letter.
He is the appointing authority. You said yes. Under which provision?
Of the
Let us see under which provision.
But your Lordship kindly then again come to page 47.
What is page 47?
That is an walk-in interview.
We are asking you whether he is an appointing authority.
All these persons, even the PTT, CWTT guest teachers, they cannot be appointed. They also given the appointment letter by the vice.
We are not asking you who gave the appointment letter. We are saying, is he the competent authority under the statute? Does he have any appointing authority power?
All these teachers appointed.
Who is the appointing authority?
All these teachers first appointed by the college authority, and thereafter their appointment has been sanctioned by the Director of Public Instruction.
Correct. So,
but this is
Director of Public
Instruction. This is not the
Instruction.
recruitment, or this is not the recruitment like PSC, Public Service Commission, that there is an examination held by the PSC and thereafter their recommendation has been made. This is not that.
We have understood. So At least I don't know the provision. I'm asking you, where is the provision? Who is the competent appointing authority? Show me.
Man, as per the mal-
Because a letter has been issued by XYZ will not make him the appointing authority. We are asking you, who is the appointing authority? Any XYZ can issue a letter appointing anyone, but that will not make him the appointing authority. So
No,
who is the appointing authority?
the college, the principal is the appointing authority, basically.
The
But
private
they are-
college.
In respect of the permanent college teacher, approved college teacher through PSC or through college service.
So
commission,
therefore,
that-
OIC is not a appointing authority under any provision, neither in the private school nor in the state aided school.
No, my lord, I am not saying it, but.
You are not saying so, but you are not saying he is a
No, no,
competent
my lord,
authority.
It is not relating to the post of college teacher regarding that teacher.
So for
When
appointment purpose, he is not a
SAC
teacher,
My lord,
but
the
for
SAC
SAC
is-
purpose, he is a teacher.
Yes, but SAC is different.
Alright, very-
SAC is totally different from this type of contractual teacher.
Very well.
SAC is totally different for this type of contractual.
All right,
That's
so
why-
we have gone through this page 3. What else? You have placed this, that under the head of department, he was taking the class.
No, my lord. What happened? The supervision means, my lord, all teachers are.
Yes, we have
supervision
understood.
of the head of
We have
department.
understood that.
That
What-
doesn't mean, my lord, that
We have
they
understood.
cannot give the teaching or.
We
If
have-
your lordship kindly go through my annexure, class wise, I have giving the routine as well as the everything I have been given. Because otherwise, class wise remuneration cannot be paid. And if your lordship kindly go through all the annexure one by one, I can show your lordship. I am showing your lordship another page 54.
Just a minute. Page 48. 54.
48, my lord.
Page 54.
Yes.
Yes.
Your lordship got it.
Yes.
The next page is the format. Your lordship,
Page 56 is the format.
yes, ma'am.
Yes.
Format. Your lordship kindly data capturing format.
Hmm?
Your
Yes.
lordship data capturing format for
Yes.
government approved PTT, TWTT, guest teacher or equivalent.
Yes.
And if your lordship kindly come to the designation part,
Yes.
guest teacher or equivalent, government approved PTT, government approved TWT. And in this regard, they say they cannot get any guest teacher at that time. That's why they are giving appointment to this person. And regarding guest teacher, I am showing that the guest teacher only appointed after the retirement as a teacher up 60 to 65. This is the criteria. And this upon basing of this.
Only retired?
Yes, ma'am.
No, guest teacher
Regarding
can,
guest teacher, only that.
serving can also come as
Yes,
gift.
ma'am.
Serving and retired both, not only
Yeah.
retired.
No, my lord. I'm saying, if your lordship kindly regarding guest teacher, your lordship kindly get it from the it order itself from the director of publication.
No,
Lordship, kindly go through the page 1106.
yes. Yes, 111, small Roman 2, serving or retired. Can't be only retired. Guest teacher can be serving also. There is no bar. From one institute, you can be called as a guest teacher to any institute, as long as you are a serving teacher. Anyway, that has no relevance here, whether it
Why
is retired or.
relevancy is that, my lord, because this circular meant for up to the age of 60 years. This circular,
Which
that
circular?
is 23rd December 2019, upon which I am banking, that this circular is meant for.
Memorandum.
Yes, ma'am, that memorandum.
Yes.
If your lordship kindly come to page 58.
Yeah.
That circular again. Page 59. If your lordship kindly come to 7 Roman 3. Both the above two category of teachers, that is state-aided college teacher category 1 and category 2, will be allowed to continue their engagement till they attain the age of 60 years old. So, my lord, regarding retired, this cannot be happened. So,
there's no question of retired. It is serving and retired both. You are unnecessarily excluding serving from the. It is the very much says retired or serving.
my lord, in the guest teacher, if your lordship can see the regarding the meaning of guest teacher in West Bengal, then generally the retired teacher.
Sir, this is the competent. This is the competent authority giving the specific provision in the impugned order. You are not showing any other provision, then we are to ignore this.
Then your lordship kindly give me the one.
Sorry, not required. Maybe.
Because my lord, why I am saying so?
According to
regarding
us,
the
that
guest
has no
teacher,
relevance.
In West Bengal, my lord, meaning thereby
All
after
right.
the retirement.
All right.
And my lord, what I am on, my lord, regarding this, my lord, affidavit which has been filed before your lordship, which shows that the petitioner has been teaching the students and my lord, impartially, and my lord, they have been teaching the students since February to 21 as per requirement. So, my lord, they can be allowed to be a SAC teacher. In respect of first one is SAC 2 and in respect of the petitioner SAC 1.
Yes.
This is my guess. And now your lordship, if your lordship kindly come to the ordering part, which has been challenged before your lordship. One 170 of your lordship. On June, Madam, may I read for your lordship?
We are reading. The Honorable Single Judge Order, we are reading. You had filed any reply to their opposition in the writ proceedings? No.
Yes.
Yes. So we have seen the order. What is that from the order that you want us to specifically? What is your emphasis on the Honorable Single Judge order? What is the infirmity? His conclusion starts from paragraph 19 at page 177.
Yes. Thereafter, the memo has been given, so my lord,
Yes.
please-
That need not, we have already seen, so we need not go through it again.
my lord, the well, the first part is that in the, your lordship kindly come to page 181,
180.
181.
Yes.
The second paragraph. The petitioner was engaged as teaching cum learning assistant.
Yes.
He is not PTT, CWTT and guest lecturer. The claim of the petitioner is that the teaching cum learning assistant is equivalent to guest lecturer and the petitioner is performing the work to the state to that of the guest lecturer. But I am saying, well, no, it should be, well, guest teacher, not guest lecturer. To decide the issue, to see what is the work is to be performed by the next paragraph, by the teaching cum learning assistant. The learning assistants have been used in lecture to assist with facilitation to PR instruction during use of personal response system. They calculate class as does the instruction, making sure all the students are engaged in discussion, promoting useful dialogue, answering student questions, and providing feedback to the instructor on the student understanding. The learning assistant have been used to facilitate group work in a variety of ways in both introductory and upper division courses, such as in lecture, tutorials, and worksheets, group work in recitations, and group work in optional course seminars. The learning assistants are being used to facilitate upgrade voluntary oral assessment offered prior to exam. Oral exams last 1 year and offered prior to course of exams. Orals are geared to improve student understanding and allow instructors to work with the student on individual basis to address misunderstanding. In the report submitted by the officer in charge of the college clarified that there is no other guest teacher and government approved PTT government approved engaged in the college prior to July 13, 2019. No guest teacher in any description has been engaged in the college after July 13, 2019. As per the report of the college, the post of teaching cum learning as was created by the Parent Teachers Association of the college, a registered trust formed as per recommendation of NAC, and the remuneration is being paid to the college fund. If your lordship kindly, see this part of the order as per the report, this is totally against the report filed by them. Present report filed by them. Now your lordship kindly come to the next page. The petitioner has relied upon the routine for undergraduate BA program general course and submitted that the petitioner has taken classes as teacher. But other than the said document, there is no other document to establish that the petitioner is performing his duty to that of guest teacher. But in this regard, my lord, the learned court below does not see that we have not only taking classes, but we are examining the papers for semesters. Not only for that colleges, but also as for the university under which that colleges is there.
No, you said that this is opposed to the report. Which provision of the report?
Yes, ma'am.
You said in the prior paragraph.
Yes, ma'am. Your lordship, can you come to the report?
Yes, which provision in the report? Which clause of the report it is violating?
If your lordship.
A, B,
Is
C,
there-
D?
Yes, ma'am.
Which one?
Is there any trust or other private body that runs and maintains the college? Since this is a government college, it runs by maintained by higher education development officer. So, my lord, the question, the registered trust form as per the recommendation of NAC and the remuneration is being paid out of the college fund. That was not there from the report. How from we got it?
Which question you are referring to? Question A,
Is
B?
there any planning committee or government body that runs the administration?
All right,
there
so
any-
it is
other
opposed,
private-
it is opposed to B.
Yes, ma'am.
B, it is opposed to B.
Director, yes, ma'am. Yes.
So many times we are asking you a
Yes.
simple question. Yes. Yes.
And your lordship kindly come to H, my lord.
H.
Was there any record of attendance of the appellant in the college? No, so record present with you. How can it be, my lord? Once they said that they are attending the college, once they said that that is not.
Yes.
My lord. So, my lord, the any fund which has been given to this petitioners also, that to be given by the government fund. Because, my lord, E is the college is aided by the government. Under what head is aid received from the state by college, how it is disbursed. As this is a government college, the college receive headwise fund from the state and disbursed through treasury. My lord, the question number E.
Yes.
So, my lord, this finding of the, my lord, the planet code below, in my opinion, it is not, my lord, correct. Now, if your lordship, the next, the petitioner has relied upon the routine such and such, submitted that the petitioner has taken classes as teacher, but other than the said document, there is no other document to establish that the petitioner is performing to that guest teacher. Well, the teacher is only examining the paper, teach the students, and if your lordship kindly come to the my annex chart, if your lordship kindly see that I'm giving the number, page number. One to seven, my lord, your lordship kindly got.
Which one?
1 to 7.
127.
Yes. Page wise, you, your lordship, can you go through the.
You are at page 128.
128, and
You are-
the 128 page is there is a your lordship, can you see
Yes, your name is there at 128.
both the petitioners name? Opu Sutrodo, thereafter Deepak Vishal. Now,
Oh, both of them are,
one is education, another is philosophy. And
Appu
129
Sutradhar is the first, is the petitioner in the other
in
case.
the other. But he is a slate qualified, net qualified. 129, Malad, your lordship, kindly go through. The following teachers are assigned for evaluation of the answer scripts during the upcoming second and fourth semester of university examination. Malad, your lordship, kindly got
Which
the name
page?
of 129, next page. The name of the present appellant before your lordship got code 8, fourth semester honor, name of the teacher Deepak Vishwas. Next, my lord, your lordship, his name code 9, fourth semester honors Deepak Vishwas. Again, my lord, code 4, second semester honors Deepak Vishwas. Then, my lord, G, fourth semester honors Deepak Vishwas.
Appu has also done this.
Yes, ma'am.
Where is that?
Case, my lord, I have done it. 130 also, man. This is a letter from the university itself, Coachbihar Panchanan Burma University. To Mr. Deepak Burman, Department of Education, AVN College. Yes, sir. I am directed to inform you that you have been appointed as an examiner of education for paper such and such, such and such, such and such. For semester 1, 3rd, 5th examination 2020 held in March 2021 of Coachbihar Panchanan Burma University. You are requested to strictly adhere to the time of such and such. You are also requested to collect the answer scripts from the office of the controller from Malad. Next page, Malad. The routine Department of Education. Malad, these shows the petitioner has been working till they are Malad, disallowed to work as a teacher of the college. Practically, this petitioner is the founder teacher of the college. And if your lordship, today I have not the pictures in the college board, thereafter his name has been deleted after filing of this appeal. But his name was in the top, that the founder teacher in the college notice board.
Yes.
Thereafter, when we file this case, and his name has been deleted.
Yes. In the second case, just point out these annexures.
Malad, page 62 is the notification.
Just give us 2 minutes, please.
Paper book study.
So this is 2222 and the other one is 2222 of 23 and the other one is WPA number.
WP number 2224 of 2020.
The paper publication in this case, advertisement page.
The same advertisement, your lordship got it from page number 51. For the post of philosophy, one teacher, one person. Next page 52 is the appointment.
And memorandum?
The memorandum is page 62.
Yes. Now those documents showing his invigilation duty and his
Yes.
evaluation duty.
Your lordship got it from 110 routine. Thereafter, all the routine has been given. 1102
No, what is this routine?
routine for the classes of the BNC college for that, my lord, philosophy, Department of Philosophy.
Yes. So
AS means Opushutra Lord. The lordship got only one page, your lordship can take 111 and thereafter 112. Monday 10:30 to 11:30, fourth period. AS. Monday
petitioner's initial is AS. AS.
AS. Opushutra Lord.
Yes. No, it's another one. But that next page there is no.
And my lord,
Yes.
in this case, my lord,
Yes. And
in
in
this
which
case, my lord, I am giving the class taken by this petitioner and my lord, signed by the head of the Department of Philosophy. My lord, page 1162, your lordship, up to page 130.
so 1162.
130.
Yes.
And my lord, Director of Public Instruction refusal is my lord, page 131.
No, and in his case, there is any invigilation and evaluation work also performed. Let us see that first. So after 20, all of you, both of you have been discontinued.
2021.
Both. Yes, could you find the invigilation in evaluation proof anywhere? So in this case, there is a teaching experience. In that case, there was no teaching. There was invigilation and evaluation. Here, there is teaching.
Teaching experience is there.
In the other case, you did
Yes,
not
yes.
point out. You only showed invigilation and
No, no, my lord, class routine. Class routine shows, in that case also the routine is there.
routine is there. Which page?
And 131,
You only placed up to 113, 130. You did not place 131.
131, my lord, I have routine for BA honors course. I am placing only one document.
131.
Your lordship got it that his name is Deepak Vishwas. So DB, small one.
Yes, got
DB,
it.
DB, DB. Also, my lord, the name of the other one is there, AS, AS.
So any invigilation and evaluation duty in this Apu case?
My lord,
No, nothing which was not on record. Sorry.
but that was not annexed, but it is there.
All right.
College authority has given.
All right. Then what else? Best teachers, oh yeah. Teaching cum learning assistant.
Not only one.
And in this case, the order rejecting your claim is a composite order or separate order?
Yes, but same order has been passed.
No, same means separate or in one order.
No, separate order
So in this case, where is that order?
is the Upusutra.
Yes.
My lord, 131, page, the director's order is, my lord, page 131. First, rejection of the director.
The font has changed. The font is changed.
Yes.
The content may be the same, but the font has changed.
Yes, sir.
This, he was also a party to the earlier writ petition.
Yes.
Both of them were
Both of
separate writ.
writ petition. Because the post is different. One is for the philosophy and another is for the education. And my lord,
So the decision is exactly the same. There is no difference. Anything else?
and my lord, my prayer is that we want, my lord,
Benefit of the memorandum, setting aside the order of the director and benefit of the memorandum. Yes. First case first.
123.
Hmm?
120. Number 123.
129, yes. You cannot say anything beyond the reasoned order. Whatever is there in the.
Submit for all the documents. In short, I'll just go to point 2-3 pages. Firstly, admittedly, the appointment was on the basis of working interview for the post of learning comes not PTIs or contractual worker or guest teacher. And from page number 48, at page 48, their appointment was by the college. It was teaching come learning assistant in department, aviation college. This kindly be noted, this service purely temporary. This post was never sanctioned by the government. I am coming to that document. Never sanctioned by the government. It was purely temporary. With no assurance of extension, subject to termination. And this whole discussion of the college also. And that was also confirmed by the report of the college. Report in form of affidavit. Question number 8. What was the nature, duty, and responsibility of the appellant in the college during his period of engagement as a teaching cum learning assistant? The appellant of Pushupra was teaching cum learning assistant and was engaged by the OIC of the Dr. B.K. Shah to working with experiment class basis at 150 per class, according to the engagement letter dated so and so,
during the period of engagement from up to 18 February 21. Next line is paragraph vital that the OIC engaged, they must stop their local arrangement having no approval from the Department of Higher Education. So it was not sanctioned by the government. And the memo, now I want to refer to the memo also, which they have also referred, the memo speaks that the memo, both the memo speaks the first line, the matter of restructuring of service conditions and other benefits for government approved. Government approved part-time PTTIs, TWPTs and guest teachers. At page, lordship, page 58. So this virtually this they have no locals to file the reason because they are not government have to or they are also never sanctioned by the department. Secondly, I have to refer the report also. Report also is in the same tune that they were appointed not by the department, they were appointed by a post which was created by Avian Hill College Parents Teacher Association. That is a trust. We can get from the appointment letter, from the certificate which they are relying, and from other documents that it was.
From which document?
From the report at page 67.
No, but you say you can get it from other document
Other
also.
document from the report, from the receipt order, and from the document which they have referred at page 50. Page 50. The certificate which they have filed. First, second, third paragraph.
Yes, what is there?
Some learning within the board, of course, the present regulations will be certain, sir. The process of approval set is going to be determined and to withhold regulation permission will be created and flat from. Sorry, para 2. However, Deepak has been rendering his intellectual and physical services teaching come in the same department of education college very satisfactory without any break in service. The remuneration is per class basis 150, then it was enhanced to 180. These remuneration shall be given out of the receipts, not from the government exchequer, like regular teachers. The receipt was collection for evidential parent teachers association. That is the trust. And this post was also created but not by the college, not by the government, not by the department, but this trust for the benefit of the public. And it will be also forwarded by the report of the officer in charge at page 67. Page 69 I will prefer. The concept of teaching online does not mean part-time teacher or guest teacher.
This is a report submitted by the OIC himself.
Himself on 8 January 2020. In this report also we can get that his appointment and its remuneration, not by the college, nor by the department, but from that trust. Bullet point 1, 2, 3, 4, 5. Hardly the reason order also gives the details. Book 110. Also confirm that the concept of teaching of learning is did not win PTPIs and as per that memo.
Yes, we have seen.
And the convent was also.
This order he has already placed, you need not place. it.
Convent has also been dealt with.
But your lordship kindly go through the report once.
Yes,
After the reasonable disposition was filed, subsequently, the disposition was filed and the reason order was passed in the that page which they was referring is a for a reason and detailed order in tune with that report and the.
so at the outset, we said you will be relying on the reason. Anything?
Yes. Page 67, it's my learned friend shows here. Your lordship asked me whether regarding engagement that guest teacher means serving. And your lordship, this teaching come learn the 1, 2, third point,
Off?
page 67.
He is nobody to comment on this.
Yes, ma'am.
The director in his order has said who is that, what this OIC will say. He is nobody to comment on this.
Malad,
We don't even know whether he is a statutory authority or he is just in the college working somewhere.
Malad, what I am.
Whether there is a statutory post known as OIC in a college.
Probably, Malad, in the government.
Probably
college,
not.
The principal or, Malad, they can say it because, Malad, it is their.
Anyway, he is nothing. He has no locus to say whether a guest teacher is to be a retired or serving. When the director has clearly in his order said that it is both, why should we go into what YC is saying?
Malad, guest teacher, what is?
That's all?
What is your lordship survey regarding guest teacher?
Yes.
Malad, I am saying, Malad, that regarding that guest teacher is not appointed in a college. Regarding college, the guest teacher who are being appointed as a guest teacher, they have been after the retirement.
Yes,
In the
that's what
government.
heard the parties. CAV. Both.
After the-
Yes.
Let-
Well,